So our keynote speaker today is Richard Epstein, who is the Lawrence A. Tisch Professor of Law and the Director of the Classical Liberal Institute at NYU Law School. It's hard to know how to introduce a person who is already known, probably to everyone in this room. He is a teacher and mentor to many of us. He is, his dozens of books, hundreds of law review articles, countless blog posts have been influencing and provoking all of us for years. And his subjects, both in writing and in teaching, span really the full range of human experience and the law. He writes about absolutely everything. He's really a scholar and a commentator of the highest rank, and I'm very pleased to be able to call him a friend and delighted to welcome him here to give the keynote address. Thank you.
Naomi and I go back a very long way. I think she was smart enough never to have me as a teacher when she was at the University of Chicago, but she was president of the Federalist Society when we put on the convention, and more importantly to me, when she, in the summer of 1997, she helped mentor my daughter as an intern at the Institute for Justice, right? So everything that comes around goes around. And as I look around this room, there are indeed a large number of friends whom I have. And so what I'm about to say, I hope will amuse them, titillate them, and maybe inform them. And I'm going to try to pick up on the two panels this morning and to try to set the thing in a somewhat broader context than it might have otherwise had been. And in fact, the way in which the discourse began this morning, it was essentially a tragedy in two acts. The first act was telling you why it turns out to be extraordinarily difficult under these or indeed any other circumstances to put together a set of fixed rules at the front end, which will then be sufficient to guide you through the perils of a particular situation. And the second panel, talking about the art of the deal, explains to you why it is when you start to do these things selectively, it turns out that the system gets overwhelmed by discretion and so forth. And so I think the first thing I want to do before I talk about some particular cases and the difficulties is to explain why it is that the rabbi was right when the famous situation came. First guy says, well, A, B, C, and D, and the rabbi says, you're right. And the second guy says, not A, not C, not A, not B, not C, you're right. And then the third guy comes and says, how could both of these be right at the same time? And the rabbi says, you're right too. And so when you have these kinds of situations, what you're really talking about is something which we can understand, which is the problem about imperfections. And the problem of imperfections has a very clear analytical framework that's associated with its operation. You pick any random practice that you have, and you discover that it has advantages and it has disadvantages. And the argument about imperfections means that when you put the practice into place, do the advantages outweigh the disadvantages, or the disadvantages outweigh the advantages? And many of the speakers this morning constantly referred to the fact that we're trying to make imperfect adjustments one way or another, and these are the tools that are available. And what happens is, if it's a question of relative preferences one way or another, no matter which way you come out with respect to the outcome, there is always going to be a very high error cost. And if it turns out that there are high error costs in all different states of the world, there is a fertile ground for endless disputation as to which set of these error costs turns out to be greater than the other. If it also turns out, as it does in connection with wars and with financial regulations, that the good days are 99% of the time and the bad days are 1% of the time, and what you're trying to do is to figure out how you don't mess up the 99% of the times by dealing with the 1% of the time, you're going to have very few events from which you can learn. They're going to all be somewhat distinct, so it's going to be rather difficult to try to develop a set of protocols which will essentially allow you to handle the difficult situations without upsetting the others. So if you start to look at the way in which the commentators went, let's go back to the first of these panels on the question of do we or do we not like fixed rules in the way in which we deal with things. And so Peter Wallison, in a burst of good judgment, which occasionally befalls him, announces that the problem about having a set of fixed regulations under these circumstances is that it creates the very difficulty that you're trying desperately to avoid. Namely, it creates the problem of systemic systemic risk. And the question is, well, why does it do that? Because what happens is the regulator comes in and he announces that in order to administer this particular system equitably and fairly amongst all kinds of individuals, what we are going to do is to put them all subject to a same rule. It turns out that the thing you're worried about with systemic risk is what we call common mode failure, regardless of how it arises. And so the regulator, in an effort to be impartial and fair amongst the various parties, now creates the very form of common mode risk in this industry. He is a regulator, and so this is even worse than a private party doing it with respect to his client, and that's true for a couple of reasons. One is that private regulators in market situations face competition from other private regulators in market situations, so they're going to be more attuned on the kinds of rules that from the ex-ante perspective are likely to work well, and so there's that thing. And secondly, it turns out that their competition essentially starts to keep all sorts of people in line, and there are fewer public choice difficulties, which will contaminate the way in which the regulator goes. And we see that under Dodd-Frank, when nobody knows what the definition of a SIFI is or why it matters. And in fact, if Peter's account is correct, SIFIs are not the problem. The real difficulty is that you have a lot of small dominoes being subject to the same kind of regulation. None of them are systematic institutions, but the risk from regulation turns out to be systematic. And so therefore what happens is what you do by regulation is essentially take the healthy part of the market and subject to regulation that makes it more dangerous than it would otherwise be. But this is only a partial account, because then somebody else comes along and says, well, what we really have to do is to understand the problem that's wrong with respect to this particular system is that you cannot essentially go to the alternative. And what does the alternative says is what you do is you treat every boat on its own bottom, every case as though it's distinct. You look to the totality of circumstances and make your final kind of judgment. And so this starts to sound perfectly grand until you realize that the same yokels who are putting into place the wrong fixed rules are the yokels who will be around putting in the variable rules to deal with case by case. So what you now do is you have substituted for the problem of systematic risk the problem of random enforcement that exists in these cases. And then the issue is, how do you start to deal with that? Because what we see in administrative law is we say that non-discrimination is actually a fairly desirable characteristic. So if you look, for example, at something that Mike Griever and I have worked about a lot, Dormant Commerce Clause, it's a non-discrimination principle because you don't want to commit yourself to a substantive set of regulations, but you want to make sure that the outsiders are going to be treated as well as the insiders. So you have that, and if you make sure that it's an all or nothing choice, it's much more difficult for a regulator to pay favorites for one set of individuals than it is for another, and hence the very rule that creates systematic risk is the rule which is thought to be able to counter public choice problems. And if you put these two things together, it turns out that there is simply no way in which you can have a monopoly operation in this system and get rid of the problem. To give you another illustration of this, there is this famous book by Philip Howard called The Death of Common Sense. And what he says is, let me give you 1,000 individual cases in which there is an absurdity by playing a particular rule to the outlier. And everybody says, God, you got to really get rid of these fixed rules. And then the moment you get rid of that, you get the other sort of cases of unequal treatment, of identical cases. And people said, boy, we have to put those rules back into place again. So it's quite clear that you need some kind of a mixed solution, a little bit of rule and a little bit of discretion, but nobody exactly knows how it is that you describe what that middle ground is going to be, because it's not going to be a clear separation. Let me give you a comparison for that by going to an area in which I work a great deal, which is actually very close to financial regulation. I see Kayla. When we did this teaching a course in land use last year at the University of Chicago, how does the system of land use evolve? It turns out it's exactly the same pattern that you start to see when you think about the situation that we have in financial markets. You go back to the first of the zoning cases. It's a case called Euclid against Ambler. And what you do is you have the same progressive planners who understand how to regulate banks, showing that they know how to understand real estate. And you take this perfect 68-foot square foot plot of land, bordered by railroads on one side and a road on the other side, perfectly suited in order to be operated as a kind of a uniform site for a large industrial plant. And what the regulator comes along and says, we have to make sure that we deal with conflicts between neighbors. The nuisance law is a way of trying to handle that, but that's too ad hoc. What we need to do is to create fixed zones of separation so as to avoid the problem of incompatible uses. And what they then put into place is a scheme which was made in hell. They create 3 zones. They configure them wrong. They have the wrong depth between them. They render each of the zones inoperable for the purposes for which it could be used. And it's upheld by our good friend Justice Sutherland on the grounds that you really have to have a zoning system to make sure that semi-trucks don't run down little children on side streets, which was not, shall we say, the issue involved in the case. And so what you then look at is you say, look, the problem about this particular case is that what you did is you try to fix this thing in advance by a set of zones. You don't have any idea what the plans are for the development. We got to introduce something in order to change this. We've got to start having about the world of the deal, which was our second panel. And so sure enough, the deal now comes forward. And what somebody says is, let's look at this plot of land. And then we have to try to figure out how we're going to do things. The advantage of this system is really quite pronounced. If, in fact, what you do is to look at this particular situation, instead of having to make a decision in 1920 about what's going to be done in 1925, you can get right up to the time, understand the changes in the conditions, and the two virtuous sides together in negotiation can work out a plan which is far better than that which you would have put into place if you had tried to do so 5 years before. And so the new information is the justification for making the deal. And the ratification of this is it works for the mutual benefit of both parties. And so therefore, by the time the deal is done, everybody ought to sit there and to applaud. It takes about one iteration to realize that the information that allows you to put into place an efficient transaction is the identical information that allows you to engage in the exaction game, which in fact is now probably the single most important issue in modern land use regulation. Because what the regulator comes across, and he says, starting with a famous case by Judge Antonin Scalia, no random association here, a case called Nolan against the California Coastal Commission. What the commission says, we will give you this wonderful permit to build this shiny new house on your property, and all that you have to do is to grant us a lateral easement across the front of the property so people could go from one public beach to another. And it turns out that the fellow is a lot better off if he gives up the easement in order to get the building permit. And then the question is this going to be perfectly appropriate because of the mutual advantage that I just talked about? And everybody immediately thinks about the situation. They say, well, let's go through this whole sequence. And then we realize in the end, the city gets the lateral easement for no money whatsoever, given the way in which this building is going to be put up. And they, of course, could have basically given the permit without this ado. So what's the inefficiency associated with the operation? Well, it's a technical but very important problem. Bundling means that you make the wrong trade-offs. If you put the two things together, it turns out that the fellow will always capitulate and therefore sort of surrender the easement. But you will have no idea whether this is a good or a bad thing because you don't know whether the easement is worth more to the government than it is to the private party because that choice has never been required to make. If you separate the two items and you're going to be forced to do it, you'll condemn more likely in the cases where it's worth doing, and otherwise you will not. And one of the most important things about the whole eminent domain and takings issue is the purpose of a just compensation clause is not just to give you compensation in the ex post state of the world when the government acts, it's to put a set of prices in front of the government so in the ex ante state of the world it won't act at all given the fact that the prices they're going to impose are too high. And so what then has to develop is how do you figure out the way in which you can sort of work through the exaction question in an efficient fashion. And I think the only answer to this comes from a body of law which has not been mentioned this morning, but which is really quite congenial to the folks who hang around the GMU Scalia Law School. And that's the antitrust law. If you go back and you start asking what's going on in these cases, it bears an eerie resemblance to such things as tie-in clauses, where the government says you can do one thing, but you can't tie it to another thing when you're dealing it. And if you then look at the law of antitrust, essentially what happens is we divide the tying conditions into two sorts. In the one case, we call it monopoly extension, and in the other case, we call it an efficient tying arrangement. And the whole body of antitrust law is designed to figure out which kinds of regulations will fall into which particular category and why. And then the question is, well, how good are we doing it? And to this, there are two answers. The one answer is, how does it work in the Supreme Court and in the lower courts? To which the response is, not so good, I'm sorry to tell you. The cases are a complete tangle and a total mess. And then on the other hand, how does it work in theory? And I'm happy to tell you, nirvana is only a click of the typewriter away. If everybody were prepared to listen to me on all of these questions, all of these problems would, of course, be instantly solved. Nobody's prepared to pay me the slightest bit of mind. And so you can now see what the difficulty is. Even if there is a theoretical solution, there is nothing which says that the intellectual or political processes will get you there. What is the correct metric in these cases? Essentially, what you do is you allow people to attach conditions to various kinds of situations, such that if the action which they're trying to guard against occurred, there would be some kind of a private remedy under the tort system. So now you can anticipate it. And then you have to worry about, since you're dealing with uncertainty, whether you're going too far or not far enough. And that inquiry, you deal with the traditional equitable balancing tradition. There's nothing else that you could put in its place. And then on the other hand, if it turns out that the thing is wholly restrictive, what you do is you strike it down as illegal, which would be the result, I think, in the case that we had in the Nolan type situation. Now, if you start to do this and then start to take it into the financial arrangement, the key thing to understand is that in the ex post state of the world, exactly the same kinds of arguments could be used when you're starting to deal with the governments in the art of the deal. The questions came up today hot and heavy as to whether or not when you're dealing with governments and you're trying to determine the question of whether or not a deal is or is not permissible, do you have a conceptual frame in order to deal with it? And indeed, we have that conceptual frame. It's the frame that's been developed in corporate law. And what that particular frame says, to the extent that you have a trustee or an officer of a corporation who is dealing with strangers, we give him the benefit of the business judgment rule. The reason why we do that is if heads, it turns out that the firm wins, and tails, it turns out that the officers have to pay back for the losses, nobody will ever take a position in government or in a corporation where they can't capture any of the winnings, but they're saddled with all the losses unless they get a salary so large that the entire deal will start to fall apart. And this is a way of saying when you're looking at business judgments, you don't look at individual transactions, you look at an entire book of sequential business, and if you think the expectation of that is positive, you're not going to try to upset it by looking at particular pieces and taking them from out of the pool. But on the other hand, if it turns out that they're self-dealing, you don't have this randomization element. You simply have disguised gifts, either to or from the corporation, depending upon the relative values of the things that are given and restrained. And the law has always imposed a fair value restriction on those particular transactions, where you actually have to get investment bankers or their ilk to come forward, look at the situation, and tell you whether or not, within a fair degree of probability, it's an even-handed transaction. I think the way in which I would put this is, in general, I am somewhat suspicious in the banking area of the ex-ante type regulation, but I'm only willing to accept the ex-post type of regulation in financial areas if, in fact, the kinds of judgments that we make in the governance of corporations are carried over to the federal government when it takes these kinds of duties. Indeed, I will go further and say when you're starting to deal with the government, the last I looked, there was no way that I could diversify my risk by saying, well, for these purposes, I'd like to be governed by the state of Connecticut. And these purposes, I'd like to be governed by the nation of Hungary and so forth. It turns out you got only one guy that you have to deal with. That guy turns out to be the federales in these cases. He has all the advantages in the litigation. And so therefore, when it comes to the question of how you impose fiduciary duties on these people, you have to be stronger rather than weaker. Why is that? Because the exit option is effectively curtailed. And so when I start looking at the kinds of litigation that I've been involved with over the years, I don't find a situation where the rule of law has been fully observed. As it turns out, I have been involved for reasons I cannot quite figure out why, in some of the litigation having to deal with the disparate impact case brought against lending companies, which I thought to be preposterous lawsuits. Reginald Brown mentioned that today. He said, very hard to figure out how you discriminate on race when you don't know the race of the people to whom you make the loans. But that didn't stop the plaintiffs' lawyers from bringing case after case in those areas. I also did a lot of work on the Durbin Amendment, and this is a classic illustration where this regulation should have been struck down on its face. Why is that? Because the following proposition holds and essentially gets you out of the difficulty. One, it says you have a perfectly successful competitive market with no evidence that anybody's getting super competitive return in an industry which has grown over the 13 or 15 years that was involved from zero in 1995 to overtaking in both the number of transactions and the dollar associated with transactions by 2008. So if you're a good governor, you say, leave successful things alone. If you're my good friend, Senator Dick Durbin, you've got a buddy who sits down there in whatever it is in Springfield and says, we don't like this thing because we have to pay too much in interchange commissions. Could you do something to fix it for us and cover it up by announcing that the public at large will benefit? And then they put this monopoly system in place. Well, the general rule on regulation is if you're trying to get yourself to optimal outcomes, you never pay hard money and create public intrigue and administrative confusion in order to reduce total output. This is not the way in which government is supposed to work. And so the appropriate thing should have been to strike the whole system down. It was interesting during the talks that we had today that nobody wanted to speak about judicial review as a credible account on this stuff. And in many difficult cases, like what kind of ex-ante regulation do we give for an industry at whole, I can understand the reluctance because I don't know what the optimal solution is. But in this case, there's a clear theory that tells you everything is wrong. And to my mind, judicial intervention is correct. And all of these cases floundered on the shoals of rational basis constitutional law, which I regard as the great bane and curse of modern constitutional adjudication in connection with regulation. I've also been very heavily involved with respect to the Fannie and Freddie type thing, not as a litigating party, but as a commentator for a variety of institutional investors, aka hedge funds. And when I start looking at the particular transactions and set it up against standard corporate norms, I say to myself, there are a lot of people who probably belong behind bars who are going to receive bipartisan accolades because they've managed to wipe out the private shareholders. And to go back to this particular transaction, I mentioned at the outset that conflicts of interest were the things that should always get you nervous. So if it turns out that you have a statute which was passed, the FHFA, the Federal Housing Finance Authority, and HERA, the whatever it is, Housing Economic Recovery Act, and put them together, the scheme and the statute was actually pretty sensible, but it got derailed. What the scheme said is the government is allowed to make these kinds of bailouts, but when it does so, it has to look at the interests of the shareholders in the transaction, because the danger of a bailout is it will be a huge gift of public monies to other individuals, and looking for the benefit of the shareholders mean you're trying to seek a win-win transaction. On the other side of that transaction was originally contemplated to be private trustees. And so you have a very nice contrast between the AIG board, which remained private, and the Fannie and Freddie board, which was essentially ousted by main force. FHFA now takes over. Ed DeMarco is a former Treasury employee, and he bargains furiously at arm's length with his best friend, Hank Paulson, to put together two deals, one in 2008 and one in 2012. And even with respect to the more respectable 2008 deal, you cannot give the government the legitimacy of the business judgment rule because the conflict of interest in the self-dealing element is so pronounced. And the one marker that I will mention to you as being extraordinarily important in that particular case is there's an exotic commodity known as a DTA, a deferred tax asset or a loss carryover, and these things were worth about $150 billion or so, and sure enough, the government managed to write those things off down to zero, throwing the companies into insolvency, at which point the takeover became perfectly well warranted. Then you go through this for about 4 years, you get the Third Amendment on August 17th, 2012, which, to paraphrase Franklin D. Roosevelt, a day that shall live in infamy, in which it turns out that the old deal, which gave the government 10% on its senior preferred, wasn't good enough. They decided to increase the amount to everything that you earn, and the quid pro quo for that was absolutely nothing. And if you try to use the fair value analysis, even a financial genius like myself could realize that any positive sum is greater than zero, and so the deal had to be on one side. It should have been struck down on a per se basis the day the thing was put into place. Now, there's a lesson here that I think is extremely important. If, in fact, you understand that there are real differences between the ex ante and the ex post state of the world, and then you understand that in the ex post state of the world, there are techniques that have developed in the private law, be it of exactions on the one hand, or of the variety of corporate benefit rules and self-dealing rules on the other, what happens is in government you actually have to apply those particular rules. The last point that I'll make, because I think I'm coming about to the end of my time, is a very simple observation. We were talked about this as wartime conditions, and the question is, what do you do in wartime? Well, one of the things that would actually be useful for people to do is to figure out what gets done in wartime. And it turns out that the model that is commonly proposed is incorrect. Is that in wartime, what you do is you forget all the rules of the game, and what you do, in effect, is that you kind of go ad hoc and so forth. Well, it turns out that people who can plan for war will know that there are a lot of biases that are created by tensions, emergency, confusions, and so forth. And in virtually every serious area of life, when you face those things, what you do is develop a rigid set of protocols which you follow come hell or high water. So to give you the low-level war situation, you see somebody wounded on the battlefield, what do? There's nothing ad hoc about it. First thing you do is you clear the air passage. Then you worry about the blood. You do it the other way around, you're almost always going to be wrong. Why is that? 12 seconds without air and you're a goner, 2 pints of blood, you can still live. So what they do is they tell everybody you must do it this particular way. Every time you get into an ER, they do exactly the same thing. No variations. The standard protocol with 3 questions outperforms very substantially the finest internist doing everything ad hoc. And so when you start getting these really stiff situations, you want to get a set of protocols of whom you ask, what you do, how you do it, and so forth. And if you don't do that, what's going to happen is you're going to make more mistakes by being responsive than you won't. What does this mean? Well, you got to get the protocol. And there is this book by, I keep forgetting the guy's name, I repress it actually, talking about intuitions and protocols and so forth. And what he does is he manages to get it wrong, thinking intuitive judgments and protocols are the same thing. Intuition works very efficiently when rational choice doesn't work. But a protocol is not an intuitive device. What you do is you spend hundreds of hours through countless simulations and tests to make sure that you hone this thing, because a protocol which has 3 steps instead of 4 steps can save you many, many lives and reduce many degrees of error. And that's what you have to do. You have to plan in advance for the thing that you will know come, and then develop these kinds of rules. If, in fact, you do it the other way, you'll just get a lot of people breaking a lot of heads, doing a lot of harms, and that, I think, is a pretty accurate description of what happened in the 2008 financial crisis, whether you're talking about whom we bail out and why, or the way in which the Fannie thing went, as opposed, for example, to the way in which the AIG went. So what this is basically is the following argument, is that, I'm a common lawyer by training. Every time I begin a discussion, it starts with, in Roman law, we did this, that, and the other thing. And my advice to most of you would be, if you actually follow that approach and went back and studied the classical traditions and the standard solutions, you would be a lot better than this frenetic kind of improvisation which seems to dominate modern financial regulation today. Any questions? Happy to answer. Any disagreement? I'm willing to tolerate. Thank you. Well, I left time. 10 minutes, 8. That's what I like. Yes, Miss Middleman. Why is it that you always are the first person to ask the question?
I hope I ask. I was just going to say, if you think that one of the problems we have is lack of judicial review and the judges don't understand your theories, have you ever thought about becoming a judge?
Well, let me put it this way. A lot of other people have thought about that particular prospect. But I like to say, in effect, I'm the kind of person who would not only be voted down by all the members of the opposing party, but would not be able to get a nomination from my own party if I only knew which it was. And so I think the fair thing to say is this actually came up. I don't know if you're aware of this, my famous moment of glory on the cover in 1984 of Policy Review as one of 4 people to be a potential Supreme Court nominee at the tender age, at that point, of 40 years age. There were 3 other people on the cover. 2 have been lost to history. The other is a fellow named Joe Ball, who died shortly thereafter, who was a religious liberty guy. And the 2 people never anybody heard of were Bob Bork and Nino Scalia. And I was put forward on this particular cover as the libertarian alternative to what was the judicial restraint people. And I was just in the business of writing my takings book, which would have permanently disqualified me. But fortunately, I'd already written my article on the Yellow Dog contract, arguing that it was the finest piece of social regulation for labor markets that had ever been devised, and that the entire New Deal establishment, which weighed out heavily against it, was completely misguided, and that was enough to sink me at that time. But so I go down to the Heritage Society, and we start talking with a man named Michael Horowitz, an open-minded, gentle soul, if there ever was one. And we enter into a battle royal, the likes of which you haven't seen since Antietam, as far as I can tell. Because I'm saying if you're a constitutional originalist and you have a broad clause, you get some broad meanings out of it. And he's saying judicial restraint turns out to be the paradigmatic value. And it turned out at the time, I think there was some sentiment for my position in the Republican Party, but most of the party was much more rule of law oriented in the narrowest sense of the law, of judicial restraints, respect for the political branches. I was not. To me, the question was one that Scalia rightly put: where you're going to get the greater level of error in judicial intervention or in essentially legislative or administrative action. And I've come to this kind of solution as the first approximation. If it turns out you're moving from monopoly, rather from competition to monopoly, you always strike it down. There's just no kind of subtle argument which is going to make this thing work. It's virtually a per se rule. If it turns out you got a natural monopoly kind of problem and you're trying to figure out how you allocate costs, you then have the following 2 rules. To the extent that the system contains implicit cross-subsidies that would never be found in competition, you strike them down. To the extent that you're trying to figure out the timing of the allocation of joint costs for which there is no particular allocation, you allow the government a very broad range on what to do. Now note, this is completely antithetical to the sort of modern view on this particular subject, which is economic stuff. What do we want to learn about that? We're judges and we pride ourselves on being stupid, right? And so we're just not going to look at this. And so it's a kind of a super deference across the board. Essentially, the test in all of these cases is you intervene judicially if you have a conceptual solution that you're prepared to defend on this podium. And if you don't, then in effect you have a lot more discretion on the other way. This also carries over to the APA and similar stuff. The Chevron decision, which says that questions of law should be deferred to the agency, says, in fact, that the fox shall entitled to eat all of the hens in the hen house, and we'll just sort of wave as they go down the gullet. And I think that turns out to be wrong, and that what you have to do is to go back to the version of it which was actually championed by James Landis, who became completely disillusioned, right, if I'm not mistaken. After 10 years of seeing the APA in action, he basically became a drunk. I mean, he just couldn't bear it anymore. Because what they did is they completely inverted the relationship that took place, and so that questions of law now became things for the agency, and questions of fact came for things for which you could get de novo review by a bunch of people who had no idea what the relevant trade-offs are. That is still the fundamental mistake. If you want to summarize it in one sentence, we have the hard look doctrine being done in connection with the seatbelt case in 1983, and that's a fact question where our friend, Mr. Justice Stevens, says, oh, State Farm, you don't have to worry about beta testing of safety devices. Just put them into place. Everybody knows it's just fine. And then you get the next year Justice Stevens giving you deference in law. If you reverse that one error and made the other corrections at the constitutional error, this entire debate would be completely transformed, and transformed for the better. One more question? Yes! You asked a question in the other session.
I did. And it's
good.
A similar question. This is Julian Garcia, formerly with the IMF.
The louder, what?
Julian Garcia, formerly with the IMF.
Okay, that's the International Monetary Fund, right?
Okay.
Yeah.
The protocol. Who designs it? Presumably the administration proposes that Congress enacts it, talking with the Fed somewhere along the line. What happens if something is not covered when wartime happens? Then who decides?
Well, first of all, when you're designing a good protocol, what you do is you try to design one which gives you an invariant first step regardless of circumstances. And that's the point of the simple analogy, start looking at the airway before you look at anything else. The thing about this, and this is a fair question that you're asking, is how did the protocols get developed in medicine? And the answer, they get developed privately in competitive arrangements. So that the ones that I'm talking about for certain of these cases get developed by either this group or that group in a different hospital. Other protocols for sorting out the differences that you have, for example, do you take in or cut out or send home potential heart attack victims? That one was developed at Cook County Hospital and tested at 15 other institutions. So the advantage that you get with private protocols is there's actually a competitive market to do it. So what you want to do when you're doing this thing in the government is to avoid the monopoly trap. You do not appoint a committee to determine the protocol which is going to govern these type of fellows. What you do is you say, this is a problem, and then you not only put this thing out to bid and take one company, Sperry or whatever it is, to do it, you have 5 different people start to do this, and then you run some kind of a runoff to see which one is going to work. That is, it turns out that the Hayekian insight is indeed correct. Decentralized efforts will smoke out errors in a way in which monopoly institutions cannot. Since government's a monopoly, what they have to do is to consciously create the competition. What's the serious problem about that? Do you know any senior official who wants to create a competitive imbalance underneath him where he can't control things? Very hard to do. What you need to do is to have a strong leader at the top who's going to say, look, this is the only way that this thing works. And for this, you'd like to get some people in business who've developed protocols. So take somebody like Rex Tillerson. He runs a company called Exante. It has the reputation of being the most careful and safe drilling company in the world. And so I say, Rex, how did you do it with respect to wells and mines? Figure out if you could do that with respect to the red button and so forth. You really have to get people who know this stuff to do it. And the single greatest problem that you get with bureaucrats is the guy at the top always says, well, I've done everything else in my life. I can do this as well. And so irony of all ironies is administrative structures are supposed to improve expertise, right? And then the guys who run it, what they do is they concentrate all the expertise in themselves. And in fact, they defeat the very kind of separate processes that you need. And my guess is if you cook somebody in the military, somebody like Jim Mattis, to pick a name not quite at random, and say how they developed their various strategic plans, my guess is that they were the good generals. They did it in a process much like the one that I'm talking about, instead of a single one-man command and control kind of operation. So that's what I would aim to do. The basic rule is always the same. In government, the options are fewer and the stakes are higher. And there's nothing you can do to stop that fundamental truth. What you can do is to minimize the hardship associated with its operation. Time for one more? Or no more? One more? Give me just a little more time. Give him a mic.
Is there something that can be done with Obamacare that's going to make that market competitive?
Oh, my God. The question is wrong, and there's going to be a short answer. Is there something that could be done is the wrong question. What 10 things would you do immediately in order to make that market more competitive is, I think, a much more accurate way to do it. And essentially, look at any particular provision and put a knot in front of it, and you'll be on the way. To be serious about it for a second, the current system, this is within the frame of the exchanges. The current system decides that they have a maximum cap on medical loss ratios, so you can only spend, if you're a certain kind of company, 15% on administrative expenses to be determined later. Just get rid of that position. Why is it that these companies cannot make trade-offs at the margin? Well, the answer is if you're a Democrat and you work in Congress, you know that the only dimension on which people ought to compete is the quality of care, and so what you do is you put price controls on the amounts there. If you're running a business, you realize realize there's always a trade-off between one thing and another. And the sweetest of all ironies on this particular point is when they put the cap on administrative expenses, selling expenses came as administrative expenses, so they couldn't market the very programs that they were trying to get to the people whom they wanted to have them. I think it's perfectly just rewards on the system, but it's a tragedy for everybody else. Second simple reform is if you find a particular device which is sold nowhere in any voluntary market anywhere around the universe, you don't mandate it because Nancy Pelosi says that this is constitutionally immune from attack. You never ever go behind it, and then you become much more aggressive in taking out anything which you only see in plans because there's some state mandates that require it. The state mandates essentially manage to drive down, because of the high cost and the low rate of return, the number of people covered through employment plans over 30 years by 10%. So from 165 million, say roughly speaking, to 150 million. That's a big part of the problem. So you want to make sure that you do something like that. Third, you allow competition on these plans to go across borders one way or another. Fourth, you get rid of all of the price control. I mean, you just go down this statute, and what you want to do is to make this an exchange. And an exchange is, in the stock market, is not, you can sell your shares. If you decide to do the following things with your internal business, what you regulate on the exchange are the risk of fraud with respect to the transactions that take place. And if you confine yourself to the common law vices through regulation, instead of having this stilted view of competition, they could have made a go of this thing. And of course, we know why they didn't do it. We talked about getting, and this is my last comment, getting opinions from diverse sources. One of the things that I've been told, and if somebody's from the Heritage Society here can correct me, please do, is that when the Obama administration decided to basically build off their plan, they thought the appropriate strategy was not to talk to anybody who tried to put the thing into place in the Massachusetts type situation. And so they never got any opinions from the other side. And I recall speaking to one prominent Obama official who said, God, when we got around the table, it was a serious discussion and we always came to a consensus. And when I said to them, you have one serious misconception. You managed to exclude from the table the only people who really had to be there. That is anybody who had some ex-ante probability greater than 0.001 of disagreeing with the consensus solution. And it's that kind of process, that narrow-mindedness in government, which is the death of these organizations, just as it is in corporations. If you got a management which only wants to hear from yes men, you got a corporation that's going to stagnate and die. And on that happy note, go back to something useful. Thank you.